Welcome. You're watching the Moody Lawyer. Justice served with experience and integrity.
Hello and welcome to the Moody Lawyer with attorney Josh Moody. Today we are going to discuss civil litigation, rights, responsibilities, and resolutions. Josh, so great to hear you, to see you today. I'm glad to have you on, and I'm excited to talk about this.
Yeah, me too. Great to be here.
All right. So how does civil litigation differ from criminal cases, and what are the stages of a civil lawsuit?
To start at the beginning, you have, in civil litigation, you have plaintiffs and you have defendants. Plaintiffs are the person who has been wronged in some way, and the defendants are the people who are alleged to have done it. We are a plaintiff's firm. We typically represent people who have been injured in a car accident. So typically what will happen is a defendant is negligent, and we'll just use the very basic. The defendant rear-ended our client's sitting at a stoplight, our client did nothing wrong, and the defendant rear-ended our client, causing injuries. They'll come into our office, we'll do what we have to do. And I encourage you to check out our other podcasts explaining the personal injury process. But somebody comes into our office and, we work the case. And then when it's time to bring a lawsuit, the difference between criminal and civil cases is that the plaintiff, you are bringing this case against another citizen. So it's kind of a citizen versus a citizen type document or lawsuit. So that's one of the main differences, is that it doesn't require government intervention, meaning there's not a police officer, there's not a government agency bringing it. It's you wronged me, and now we're trying to recover damages. That's probably the biggest thing. And the second part of your question is the key stages. The first stage is filing that initial lawsuit. We prepare the documents, and then with a list of what happened, why my client was wronged, and the remedies for that wrong.
Okay. What are some other common types of civil cases you handle?
Well, we are a personal injury firm, so that's probably the vast majority of what we do. We have handled some unemployment cases for wrongful termination, but those are a small part of our firm. But the same thing, you are an employer, you wrongfully terminated our client for certain reasons. There are reasons why you cannot terminate people either under federal law or under state law. But the same thing, we can't come to a resolution, so we have to bring a lawsuit. There's a plaintiff, there's a defendant. It's a private action. And so it's charging document. This is what happened. This is the law, and this is the violation, and these are the remedies.
So how do you approach civil cases? How do you approach it differently than a criminal case? Like, what is your process?
Well, yeah. So differently is timelines are definitely different, but more importantly, as a plaintiff, we're more in control of a case than a criminal case. We're in control because we decide when we want to file. We're in control because we decide where we want to file and if we need to file and how to file.
You're not reacting to.
We're not reacting.
Yeah. Okay. Makes sense.
Yeah. We are much more proactive, and we are in control of the case. Now, that doesn't mean we get our way every time, but it means we act first. We're more proactive, right? In a criminal defense case, we're reacting. We have to wait for the government, the district attorneys to move. We have to wait to receive the charging. We have to then respond to what they are saying. The roles are kind of reversed in civil litigation. And being plaintiff's attorney, we issue the charging document, we issue the complaint, then we have to wait for the response from the defendant. And in California, you have 30 days to respond to a complaint. So we file the case, and then we wait for the response from the defendant. So that's kind of the difference. It's more proactive on the plaintiff side. And we have time to get our case together before we make that filing, meaning we have all the medical records, we have all our witnesses, we have liability established before we file our case. So it's on our time a lot more.
Yeah, that makes sense. And what we hear the terms mediation and arbitration a lot. Can you explain kind of what those are and at what point those should be considered as an option?
Yeah, so mediation is voluntary for the most part, where you go in with a third-party neutral who's not a judge, but a lot of times they are a former judge, retired judge, a lot of time, not all the time. And you're just and it's a lot more informal. You are basically telling this third party this is what I can prove, or I think I can prove, and this is what I think it's worth. And the other party saying, oh, you can't, they're reacting and saying, you can't do this, or you can't, okay, well, we agree with this, but we disagree with that. And you're using the experience of the mediator to say, I think they're right, or I think you're right, and try to come to some sort of resolution. But typically, mediation comes after a lawsuit's been filed. You can mediate a case before it's been filed. I have done it, but it is not that common. And the main reason is because the defense wants to know all of the cards that we're holding. And a lot of times, even if I give it to them, I want to know all the cards that they're holding, but you can't compel that. You can't force that without a lawsuit. So it's more voluntary than it is mandatory. And typically by the time you get to mediation in California, you are prepped for trial. For them, at least I would say 75, 80% prep for trial. In California, arbitration it can be binding or non-binding. And that is it's still less formal than trial, but it's more formal than mediation. There you are actually presenting it, again, to a third-party neutral who is typically a former judge, retired judge. Not all the time. Sometimes they are attorneys with a lot of experience. And you submit your case like you do to a jury, but it's to one person. Typically, it's more expensive because you have to hear the testimony. And sometimes the arbitrator will just submit on previous statements, transcripts from previous depositions. But in California, a big part of arbitration is uninsured motorist or underinsured motorist, where you pay for insurance from your own insurance company. You cannot sue your own insurance company. You have to arbitrate with them. And again, arbitration in a lot of lawsuits, and you're in business with, let's say, business X, and there's a dispute, and you guys have had signed a contract that you've agreed that you will not sue each other, but you've agreed that it will go to arbitration. And you'll see that if you look in the news, a lot of times there are cases that are settled and they say, well, if there's any problem down the road, we agree that no lawsuit can be brought up out of this contract. We agree to arbitrate. Or arbitration clauses. A lot of times those are in non-disclosure agreements. So that's the difference between mediation and arbitration. Mediation, less formal. Arbitration, more formal, but not as formal as court
as a trial
and no jury.
Right, no jury. Okay. And when taking on a civil case, how do you evaluate whether it can be settled out of court or whether it probably is going to need to go to trial?
Some of that's in our archives. We've done some of those, discussed some of those cases about the process of a personal injury case. So I obviously encourage everybody to check those out, but you just don't know at the beginning of a case. When somebody comes in, you really have to investigate the case. You really have to go through the case, and you have to just work. I always say you just have to work the case. Anybody who says at the second you walk in, I know this is going to trial, or I know it's not, they're telling you what you want to hear. You have to take it step by step by step. So when a client comes in, let's sign up and let's start investigating this case. Let's get the police report. Let's talk to witnesses. Let's get the medical, you get medical treatment. Then let's decide whether or not let's try to resolve this without a lawsuit. If we can't, then let's file a lawsuit. Then let's go through, let's do our depositions. Now let's go do our witness depositions. Now let's do our expert depositions. Let's make contact with an expert and ask them for a report. What do they think that they can testify to? So during all of these stages, I always tell people, especially if it's ready for trial or going to trial, the case you have today is not the case you had 4 years ago. And I tell people that when you walk in, the case you have today is not the case you're going to have 6 months from now. It's not the case you're going to have a year from now. It's not the case you're going to have 2 years from now. It's constantly changing and evolving. For me, my position is just keeping the client informed every time there is a change or there is something new we heard or some type of new evidence. And sometimes that evidence comes from us through our depositions, and sometimes it comes from the other side. Hey, we deposed the plaintiff driver or the defendant driver. Man, that person does not testify well. I think we have a great chance of putting this guy on the stand or this woman on the stand in front of 12 jurors. They will not do well. Mm-hmm. Sometimes it works the other way. So you just kind of at different stages, the cases are constantly evolving. So, and that's one thing I always tell people is just the case you have today is not the case you're going to end up with.
Yeah, that's an interesting point. Like when you depose somebody and then you could be like, oh, this guy's not going to do well when I'm talking to him in a courtroom, or this person's got the right personality and the right disposition to be able to handle that kind of pressure. And that could I've never would have thought of that, but that makes a lot of sense as something that would be a really strong way to tell if it's a good idea to go to trial or not.
I mean, even something like medical injuries. Somebody comes in and says, I have the emergency room told me I broke my foot. Oh, okay. They said it's broken in half. Okay. And then you go out and you go to an expert, and the expert says, an orthopedic or something, and they do more than an x-ray, they do an MRI, and they say, oh, it's not broken. There's some other condition, like there's some calcium deposit that's built up or bone spurs. So it's like, ooh, now our case is kind of changed because it's not broken. It was a misdiagnosis at the emergency room where they're, turning people, constantly facing emergencies.
Fast, yeah.
Now you saw your primary care and you saw your specialist, not the other side specialist, your specialist who says, yeah, it's not broken. This is something else. Again, that's turns in, and it goes the other way too. It's actually more common the other way. They go to the emergency room, they can't find anything. You go to a specialist and, oh, we found a tear in your shoulder or in your back that wasn't seen at the emergency room. So that happens too. Again,
right.
You came in with just a little bit of back and neck pain. A month or two after seeing the doctor, now you have some sort of muscular tear or tendon tear. Not the same case it was 2 months ago. Yeah,
and sort of piggybacking on that, obviously everybody who comes to you wants a quick resolution. I mean, no one wants a lengthy battle or anything like that. But how do you manage people's expectations and prepare them for the possibility that this is not going to be a quick process? That's got to be kind of difficult.
So I do try to keep them informed, and by telling, number one, of any case, the number one priority is you getting better, however long that takes. So if you want a quick resolution, I'm not a medical doctor. I can't. So however long it takes you medically to get better is how the case kind of starts. If you want to, also the other thing is, if you want a quick resolution, you're not going to get a very high resolution. If you want to settle it quick, you're probably not going to put the work into the case to get the maximum value. And that's fine. If you want it to be, I tell people, this is your case. What do you want? If you don't want to go any further and this is what you want, we'll do it. And, I get paid based on a percentage of what you get. So obviously I want the maximum amount of money possible. But if you don't want to do the work and you need a resolution today, and there are reasons why that may be, it's your case. You make the decision, and I support it. So and managing those expectations, it's letting the clients know when there's been a major development or something that's changed. And typically the client knows before I do, but they may not know the impact of the case, meaning the client knows about their injuries before I do, because one, the doctor tells them first. If the client calls me and tells me that there's some sort of different injury, which a lot of times they don't, but let's say they do, I'm still the second person to know. But usually it's when I get the medical records, which can be several weeks or several months later, which is when I actually review them. So those are the expectations that you try to manage. And again, in managing expectations, hey, you told me you had a broken foot. And yes, the emergency room may have told you that, and their medical records may reflect that. But here's your orthopedic telling you, who's 40 years experience is telling you, no, it's not broken. And we have a different game plan for you now medically than we did at the ER. So keeping the clients informed of key stages is important in managing expectations. And sometimes it may take weeks or months for there to be a change in circumstance on a case, because again, it depends on how you are doing medically.
Right. Yeah. That's a big part. That's a big part of it. Yeah. You got to get better or be able to handle the trial. Right. I mean, they got to first things first, get better. And then you got to move on from there.
Yeah. And yeah, if you do want a fast resolution, and if you come into my office and tell me I want a fast resolution, I'll do it. I'll follow that game plan. But you need to I will also tell you the negatives of a fast resolution.
Right. All right. Well, thank you for joining us on the Moody Lawyer with attorney Josh Moody. If you want to get in touch with Josh, please visit moodylawyer.com. And don't forget to like and subscribe and stay up to date on all things law in California. Josh, thanks so much for being here. I appreciate your time.
Hey, thanks for having me. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.